When I get calls about domestic violence related arrests, I'm often told that this was a complete misunderstanding. And I'm asked if the alleged victim can go into court on that first date and ask that the charges be dropped. The answer to that question is always absolutely not. These charges of domestic violence will never get dropped at the arraignment, and it's a terrible idea to have anyone speak to the prosecutor on the defendant's behalf except his or her attorney. Family members can and often do make things much worse, even when they're just trying to help. These charges are not the victim's to drop. It's not the victim filing the lawsuit against the defendant. It's the government taking out these criminal charges, and they will fully prosecute domestic violence cases despite the victim's wishes. At the arraignment, the prosecutor might ask the judge to order that the defendant has to stay away and have no contact with the alleged victim. And in some cases, that might mean that the defendant has to move out because he or she lives with the alleged victim. And that can be ordered even over the objection of the alleged victim who wants the defendant to remain in the home. In more serious cases, the prosecution might ask the judge to order that the defendant either remain in custody or be placed in custody and remain there until the entire case is over. These are all reasons why it's super important to contact a qualified and experienced criminal defense attorney if you or someone you love or care about has been charged with a domestic violence related offense. It's important to have an attorney that you feel comfortable with and have confidence in during this difficult and delicate situation.